Welcome back to. Today, I'm breaking down a Senate Judiciary Committee hearing that had every law student on the edge of their seat. Senator John Kennedy put the nominees for U.S. District Court of North Carolina through some of the most intense questioning I've ever seen. Let's get into those key moments, because trust me, you'll want to hear how these nominees held up under fire. First up, the famous burqa case.
Thank you, Mr. Chairman. I'm sorry, I can't see that far.
Bragdon, me?
Who wants to volunteer?
Senator, I would be happy
Let's
to
just
go
start in the
first.
middle and we'll work to the end. Tell Mr. Also,
Orso, yes. thank you,
I'm
Senator.
sorry, I really can't. I guess I need to get new glasses. Mr. Orso, let's suppose, imagine this situation. Small printing company, they manufacture envelopes, stationery like that sort of thing. 20 employees, small operation. They take customer orders, go in the back, print the stuff. They wear uniforms because the owner wants to promote his company with the company logo. Employee shows up one day in uniform, but she's wearing a burqa. And the owner says, you can't wear a burqa here. And the employee says, yes, I can. And the owner says, you're fired. Tell me how you'd analyze that case, what questions you need to know, who would win, who would lose, according to Supreme Court precedent.
Sure. I would likely look first to Title VII of the Civil Rights Act of 1964, since
That's
it's
correct.
an employment case.
Kennedy kicked things off with a classic hypothetical. If a printing company fires an employee for wearing a burqa, who wins under the law? The nominee called out Title VII, no religious discrimination allowed.
And what's Title VII say?
It says that a person cannot be discriminated against in employment on the basis of race, color, national origin, religion,
Right.
gender. And then I would apply the facts of that case, pursuant to
What
any-
facts would you have to know?
I'd have to know if the wearing of that burqa was indicative of any potential religious, closely, sincerely held religious belief. And then if so, would analyze it from there.
But Kennedy wasn't done. What if the boss claimed it was about safety? Then the answer got trickier. The nominee explained,
I don't believe that would be sufficient justification to discriminate against someone based on religious belief. I think you'd have to take into account whether the employer is providing any type of accommodation that allows for that person to.
What if
to
the
work there.
small business owner said, it's dangerous? The employee might get the burqa caught in the manufacturing apparatus.
I think I would have to look at the case law if there's anything similar on that, but my instinct is that, in terms of protecting the safety of employees is a valid concern of an employer.
Okay, fair enough.
Next, Kennedy tested their memory with a question on supplemental jurisdiction. One nominee admitted he hadn't thought about that since law school. Brutal honesty, sure. But Kennedy didn't let up.
David, I really
Bragdon.
can't see. I need to do
It's
something. but-
Mr. Bragdon. David
Bragdon.
Bragdon, thank you.
Mr. Bragdon, tell me about supplemental jurisdiction.
Supplemental jurisdiction, I am having trouble remembering that term because it does not come up in criminal practice very much, but I believe
It's
it's
going to come up in
jurisdiction-
federal district court
Absolutely.
every other Thursday.
And I will certainly carefully research any issue that were to come before me if I'm
It used to be
confirmed.
called pendant jurisdiction. Does that help?
But I think it's jurisdiction that builds on jurisdiction. I'm thinking it builds on jurisdiction of another party who's already properly before the court. But I don't specifically remember Senator Kennedy.
Reminding everyone it used to be called pendant jurisdiction. When Judge Rodriguez stepped in with a textbook answer, it was clear who had done the reading.
Judge Rodriguez. And so I am a sitting U.S. Magistrate Judge right now, so I think that I'll step in for the panel. There was a recent Supreme Court case on this. So supplemental jurisdiction is when the court would have original jurisdiction over some sort of federal question, but then there is a state question. And so that's where the court can exercise its discretion over supplemental jurisdiction. A lot of times where that comes up is if something gets, the court could get divested of its jurisdiction if a plaintiff dismissed everything, all of the federal claims. And so it goes back to a jurisdiction issue, and that's what you would be normally looking at.
Okay.
Then came the basics. How do you amend the Constitution? Article 5, of course, 2/3 of Congress or the states propose, 3/4 must ratify.
I think you'd look to, Senator, I think you'd look to Article 5 of the Constitution and follow the instructions for 2/3 of the legislature or 2/3 of the states.
Okay, fair enough.
Simple, but if you fumble the basics, Kennedy's going to notice. Things got even more intense with injunctions. Kennedy wanted the difference between preliminary and permanent injunctions.
A preliminary injunction, well, let me start with a permanent injunction would be a final judgment in the case that occurs after the completion of all the litigation.
What do you have to let's start with the preliminary. What do you have to prove to
Sure.
to
For
the
a
judge?
preliminary injunction, there's several standards the court looks at. You're looking at irreparable harm. You're looking at the likelihood of success in the merits in the ultimate case as it goes through court. You're looking at balancing the equities of the parties. So those are some of the factors the court considers and whether to grant that. And it's essentially, the idea is, can you keep things in place while the litigation is pending?
What factors do you look at for a permanent injunction?
Well, the permanent injunction would depend on the relevant law or action that's being considered.
Yeah, but what factors do you look at for a permanent injunction?
So for a permanent injunction,
You
I
look at
think
the
that
same
that-
factors, don't you?
I think that, in my mind, a permanent injunction depends on the underlying statute or relief that you're taking, and it can vary based on the kind of case.
Well, in a
that's
preliminary
pending.
injunction, you're asking, is the plaintiff or the movement likely to succeed on the merits?
And
In
so-
a permanent injunction, you're asking, has the party succeeded on the merits?
Correct.
Right?
Some nominees stumbled, but here's the gist. A preliminary injunction is temporary, decided fast to prevent harm before a case wraps up. Permanent injunctions? That's after the trial once the dust settles. Critical stuff for any federal judge. Finally, Kennedy brought out the Rule 23 pop quiz. Can you name the elements of a class action?
Senator, I believe you're referring to Rule 23. So in order to have a class action, you're allowing one plaintiff or just a few plaintiffs to stand in for a class of a larger number of individuals. To bring that class, you have to meet the factors that are set out, the elements that are set out in Rule 23. So we're looking at numerosity, typicality, representation, numerosity, commonality, I believe, but those are some of the factors in it.
Some nominees blanked, others managed numerosity, commonality, typicality, and adequate representation. It was a real-time test of who's courtroom ready and who needs a little more prep. So, did Kennedy expose real weaknesses, or was it just nerves? Drop your thoughts in the comments. Hit subscribe for more behind-the-scenes breakdowns from. I'll catch you in the next one.